Now, one thing I want to kind of begin to touch on here, and Carrie mentioned that the fact that security and privacy, cybersecurity or data security and data privacy are different things. And so we need to understand that data security and privacy are different things. And at the same time, we also need to understand that data security and data privacy, if we're doing this right, if we're thinking about it right, inherently have to go together. A phrase that we often talk about in the privacy and cybersecurity field when we're talking about this overlap is this one here. You can have security without privacy, but you can't have privacy without security. And what do we mean by that? Well, when we talk about data security and also data privacy, we often talk about something called the CIA triad. Now, I'm actually, in giving you this here, I'm giving a little preview of some stuff that we'll do in the third module of this certificate program in the spring, because we'll delve a lot more into these kind of compliance principles in the spring after we've done this background of kind of the law and policy in this module and the next one. But one of the things we'll spend some time on is the CIA triad and some other things that relate to it. So C is confidentiality, and I is integrity, and A is availability. And whenever we're thinking about data security and the use of data and how it relates to data privacy, of course, confidentiality is the principle that if someone doesn't want private information exposed about them, or if our client or our business as the owner of certain data doesn't want it to be exposed, that we want to keep it confidential. But confidentiality alone is not enough. We could keep data perfectly confidential if we simply encrypt it in a way and throw away the decryption key, right? So all we have left is ciphertext. We have no plain text at all. Perfectly confidential, no one can read it. But then the data does not have integrity. We've lost what the data actually is, what it actually is supposed to represent. We've kind of torn apart the sign that the data is from the meaning of what the data is. And the data is not available to us. I mean, data is not something that has value inherently, like, say, gold. For whatever reason, human society has put a value on gold, and so it inherently is worth something. Data isn't really like that. I mean, data has value because it does stuff. It allows us to do stuff, to learn stuff, to do our business, to move forward. So, if we have confidentiality, we get a perfect confidentiality by just destroying the data. And actually, sometimes in cybersecurity and privacy compliance, the right answer is to destroy data that we don't need. But if we do that, obviously we lose integrity and we lose availability. So this is why we're saying you can have security without privacy, because you can have perfect security and destroy the CIA of the data. But the data, in being kept confidential, still has to have its integrity and its availability. At the same time, we'll say you can't have privacy without security. I mean, if we don't have security, then we're going to really completely lose this bucket of confidentiality. So in this sense, privacy and security go together and kind of have to work together, like the proverbial peanut butter and jelly. Now, as we go through the law of security and compliance, security and privacy, we'll see the differences and the way the law treats some of these things differently. We'll also talk about ways in which comprehensive privacy laws do also include, to some degree or another, some security concerns as well. And in fact, I'll touch on some of that in this presentation on private law. But as we're talking about these principles and the way that privacy and security go together, we talk about, and I'm mentioning private law and public law. So what do I mean by that? Public law is the law that first of all, puts together the society. So think of our Constitution in the United States and the way it has different branches of government. It says which branch is going to do what. So that's public law. Public law is also the government kind of telling people the parameters of their activities. So criminal law is a kind of public law, and then regulatory law is a kind of public law. And a lot of what we're talking about today, and in our next session on state privacy laws, and then later when we talk about emerging technologies, we're going to be talking about forms of public law, comprehensive privacy statutes, state privacy statutes, sectoral privacy statutes, and regulations, all of which are a form of public law. And I think that's often where our kind of mind first defaults to when we're thinking about privacy and data security and law. But it really, in the American context particularly, is not the default posture. Now, Carrie kind of mentioned some of that deep history of the concept of privacy and data privacy, and why, particularly in the European context, privacy has been seen as a human right. And the way that privacy has been embedded, and again, if you take module 2 in February, we'll go in depth into the GDPR and the European view of this. But the American view of data privacy has really not seen it in exactly the same way. We have, of course, seen human rights issues and civil liberties issues connected to privacy through the Bill of Rights, search and seizure and things like that. And as Carrie mentioned, through the due process clause of the Constitution, and we have questions about where all that stands now. But with what we consider ordinary PII, our personally identifiable information, like your name and your address and your credit card number, and the sorts of things that a lot of business-oriented privacy law is addressed at, we really default under American law to contract. And by the way, under private law, we're going to put contract. Those of you who are lawyers or law students will know we use this letter K to mean contract. And we use torts. Torts is the law of harms or injuries. And we use property. And those are sort of the core areas of private law. And what they're governing is primarily not the government's relationship to the individual, but the individual's relationship to the individual, right? So if I want to make an agreement with you, that's contract law. If I run into your car at the stoplight, that's tort law, right? If you steal my cell phone, right, that's property law. Now, of course, there's law that undergirds all of that. There are public institutions like the courts that undergird all that, but we call it private law. All right, so contract, classic form of private law, and there's an important sense in which contracts, certainly under the American, Anglo-American, and American system of law, perform a kind of regulatory function, or we might better say that some areas where there could be public law regulation, government laws or government regulation with specific standards, we might decide to not have those and to let the risks of things be adjusted between the parties. And I'm going to go here for a little bit of theory and then into the some particulars of contract law as it relates to privacy and data security. So classic microeconomic theory, which undergirds kind of the Anglo-American view of the role of contracts. Anytime you enter into a contract, whatever kind of contract it is, there are risks. And a big part of what a contract is doing is adjusting for those risks. And the classic theory says it's the parties to the agreement who are really in the best position to determine what those risks are, what the cost of those potential costs of those risks are, what the risks are worth, and how they're going to agree to make adjustments for those risks. And so the idea here is that it's what the best thing the law can do in this kind of domain is simply facilitate the making and enforcing of contracts. The underlying law of contracts tells us how to make contracts. It tells us what kind of remedies can be had if a contract is breached. And there should be minimal additional regulation of what the terms of the contract are. Now, of course, there are lots of places, and privacy, as we will see, privacy and data security is one of those places, where public law steps in and says, actually we don't think that contracts alone are doing the job, and we need some public law to step in and to actually define what kind of terms can be in certain kinds of contracts and what kinds of remedies can be available if there's problems with those terms. So there's this important sense in which there's a public law overlay to this private law of contracts in certain areas where society decides there are other kinds of harms or other kinds of risks that the contract itself is not going to adjust for. All right, so here's just a little bit of a example, right? So let's say I am a farmer who farms bananas, and you are an owner of a small produce shop. All right, so you're going to buy bananas to put in your produce shop, and you're going to just pay me a certain amount of money, and that we agree upon. And on a certain day, by a certain day, I'm going to deliver to you the fresh bananas. Now, when we're entering into this very, very simple deal, we know there are certain risks inherent in that deal. From the perspective of the buyer in particular in this kind of deal, the seller's risk is they don't get paid, but we can just determine when payments are made and on what condition. From the buyer's perspective, there's a risk that the produce could be not delivered. I never show up with the delivery, and that week you don't have bananas for your customers, or the delivery is late, or the product is damaged or spoiled, right? All those sorts of things we can think of. So in the agreement, right, in the contract between us, we're going to make some adjustments. It might be that you pay me some amount of money up front and the remainder on delivery. It may mean, in addition, that there's provisions that if I don't deliver on X number of day, I'm liable to you to deliver additional bananas or to pay a certain fee, or if the product is spoiled, that you have a right to reject the product, and all of those things can be adjusted for in our contract. And those of you who are lawyers or law students who have taken or remember taking commercial law, the UCC, there are also laws that kind of identify default rules in commercial transactions for a lot of these things. All right, now what happens when we're not talking about bananas, but we're talking about information, we're talking about data, and in particular, what happens when what we're talking about is sensitive information, is the kind of information that the property laws, the privacy laws and regulations that we're looking at today and throughout our modules in this whole program call personally identifiable information. Again, social security number, credit card number, name, address, things of that sort. And we might say that let's take a individual kind of setting like a social media platform that we might interact on. Let's say our professional LinkedIn platforms. Some of those we get some basic services for free, or we could take other kinds of interactions like a shopping platform where we're buying a product, but we also, in doing that, are giving data to the person who's selling the product, and they're collecting that data, and in some way they're going to also monetize and use that data. So let's first start with the kind of classic social media context. And as the individual, right, you're giving the PII to the company, and I've just got an image of the company's servers here, right? Your data is on their servers, or more likely is probably spread out in the cloud in whoever they're contracting with, and we'll talk about that third-party risk in a little bit. And you're getting some service in return. You're getting access to the LinkedIn platform and to the networking and information that you get for the LinkedIn platform. So, what are the risks of that contractual relationship? And we can think of lots of them, but right off the bat, if we're thinking about PII, we can think of, well, my PII might get misused by the platform. I mean, what do I mean by misuse? Presumably, I'm a savvy enough consumer that I realize I'm not just getting LinkedIn for free. I'm giving them some information about myself, which they now have, and they're going to use it for some purpose. And I might have some expectation of what I presume they would potentially use it for. You know, maybe I realize, all right, they're gonna send me targeted ads on the platform, or they're going to have people on the platform who maybe paid a premium to reach me with certain information or services, and my information might filter into that. You know, I might not expect other uses. I'm actually going to go off LinkedIn for a minute, but since Carrie mentioned, you know, Facebook and Cambridge Analytica, you know, I might not ordinarily expect you're going to be allowing some entity that is going to try to influence election results in a way that's not really transparent to be using my data. I might consider that, you know, misuse from my perspective. Now, as Carrie mentioned, you know, the Facebook agreement at the time allowed those uses. And so that is a way of contractually adjusting that risk of misuse, or at least of specifying what is the expectation, the agreement of how the information is going to be used. And of course, the problem in the Cambridge Analytica context, or one of the many problems, is you have an enormous terms of service that nobody reads, which is also something Mark Zuckerberg testified to when he testified in those hearings in Congress, right? So that's one of the risks. A contract might adjust for it. We might need public law to back that up. A risk of loss. So what if LinkedIn or Facebook has my personal information? They're using it in some way that I have an expectancy that they're going to use it. So that's part of the deal, right? That's part of my bargain of using the service. But they lose it. They are breached. A third party acquires it. It's suddenly on the dark web. And what happens then? You know, what kind of rights, if any, do I have then? Another one of the very big risks. And we're going to spend a fair amount of time in this session on private law, actually talking about data breaches. And this is this place where, you know, data security and data privacy are really closely intertwined. In particular, is in how the law is addressing data breaches, including private law. So loss, and then third-party disclosure. And by this, I don't mean, you know, a breach where it's sort of inadvertent, but what I mean is, and it connects to this idea of misuse potentially, because LinkedIn is going to have business partners that it's doing business with. It may be something as kind of mundane as who is actually providing the servers, the cloud, the part of the cloud on which LinkedIn is operating. In all likelihood, it's not LinkedIn itself, it's Amazon Web Services, or it's some other provider of that kind of thing. So my data information is potentially going to be disclosed to that third party because they're going to be hosting it. And then other parties who might be marketers, who might be other data brokers, that kind of disclosure can happen. So when we're talking about PII, a contract can and will in some way adjust for all those risks, and the terms of service that LinkedIn offers or that Facebook offers, or if you're a business entity, business to business offers, is going to address all those things. And so we might say that's fine. We might say we're gonna leave it to that place. We're gonna let that risk entirely be determined by contract. That in fact has in many ways been the default posture in the US, whereas it has not been the default posture in Europe. Now we'll say in many ways we'll qualify that. We'll see how some aspects of state law intervene. We'll see also tomorrow when we do the SIP boot camp, also how some areas of federal law intervene. And I'll also talk today about some very specific kind of potential recent interventions. But that's the background, and in this context, you know, assume that what public law is doing, what regulatory law is doing, one important piece of it is actually modifying the range of possibilities for these kinds of contractual terms. So in one sense, this is a fairly simple or intuitive example of an individual giving PII to something like a social media platform in return for some services, and it's something that's in many of our consciousness because it's in the news, and we know there's a lot of issues about the role of social media, a lot of discussion of that sort of thing. And so there's a relatively intuitive, perhaps, set of answers about the nature of those terms of service and maybe what sorts of things they should be able to contain and not. One that is perhaps a bit less intuitive unless you're really engaged in this industry, which I think is really interesting and important and plays a much bigger role in data security as related to data privacy than most people think, and particularly in this question of the problem of large-scale data breaches. And Carrie mentioned this as well because she talked about the PCI DSS standards within the payment card industry. And I actually want to take a moment and dig a little bit into how all that works and how those standards fit into what is really primarily a contractual adjustment, a private law adjustment of the risk of data security and data privacy. So, we all have payment cards. It could be a credit card or it could be a debit card. They function essentially the same as far as all of this is concerned. So you have a brand, Visa, MasterCard, Discover, American Express. Those are the major brands. They have Visa and MasterCard have, I believe, something like 80% of the market together. And the others have a little bit, and there's a few others out there, but these are the main ones. And the credit card brands are a brand. Visa is a brand that has a lot of value in itself, but they're not only providing the brand, they also are providing network services. The network services that are provided by Visa and MasterCard are an enormous multi-billion-dollar a month network over which billions upon billions of transactions flow on a regular basis. It is, in a sense, a kind of intranet. It's connected in many ways to the public internet, but it is its own kind of network, and it is massive and hugely influential over the world economy. Issuer banks are the banks that give you and I our debit cards or our payment cards. So maybe it's Chase, maybe it's Capital One, maybe it's a local bank, whoever it is. There's some bank that's issuing to us our card. Those banks have contracts with the card brands. We, the credit card and the banks, are paying membership dues and as well as per transaction fees to the card brands. We, the card customers, of course, have contracts with our issuer banks, and under those contracts, the issuer bank is extending us some credit and/or is extending us access to, the ATM network and to payment systems, and charging us, if it's credit, charging us some interest, or if it's banking, perhaps charging us a fee or making money in some other way from us. But it's a contractual relationship. There are also acquirer banks. The acquirer banks are those that work with the merchants. So the entity from whom you are buying some product or service using your payment or debit card. The acquirer banks are processing the transactions on behalf of the merchants. So what happens when you make a payment to the merchant, which is also a contractual relationship, and we have a contract here. When you make a payment to the merchant, you're making your payment, you get your goods or services. It is not the issuer bank that reimburses the merchant for that payment, it is the acquirer bank. The acquirer bank reimburses the merchant for that payment and takes a little VIG, a little discount on that payment. The acquirer bank then charges back to the issuer bank and gets reimbursed for the payment that the acquirer bank made to the merchant. And again, there's a fee in between there. The acquirer bank, of course, is also participating in these network services, and is also getting membership dues and per transaction fees. So you can see here, we've drawn a really neat web of a bunch of contracts. And this is actually a fairly simplified graphic. There are third parties called payment processors who often serve as a kind of intermediary between acquirer banks and merchants, and serve a different role. So it's a little more complicated than this. So what happens? There's a data breach, let's say, which is usually the case at the merchant. And it's a large-scale data breach, and what are the bad guys looking for from the merchant? They're looking for the PII of the merchant's customers, and that will include name and address and things like that. It is also going to include the payment card data. And if we were doing this live, I ask how many of you have had a fraudulent charge on your credit card or your payment card. Almost everybody has. The acquiring banks and the issuing banks with the card networks have gotten really, really good at fraud detection. And as you probably know, if there is a fraudulent charge, under all of the major credit card brands that we've named, the issuer bank will reimburse the customer 100%. In the US, federal law requires reimbursement with a sort of deductible of something like $50. But contractually, all of them are reimbursing 100%. And by the way, if you see a commercial for one of the credit card brands that's sort of celebrating its fraud protection or reimbursement program, that's great. They all have them. It's really not a distinguisher, right? So the issuer bank has maybe a million, so maybe there's 1 million customers who are part of this breach, whose credit card data has gone on the dark web, and whose credit card data has been used in fraudulent transactions. And so now the issuer bank is out, more than $1 million, maybe tens of millions of dollars. Is the issuer bank stuck with that? Well, this is where PCI DSS that Carrie mentioned comes in. As part of these network agreements, what's called the Master Services Agreement that Visa gives, that the issuer banks and the acquirer banks have to sign on to, which then becomes incorporated in the terms between the issue and acquirer banks, as well as the banks and the merchant, as well as the issuer banks and the card customer, has these security provisions. And as Carrie mentioned, it's kind of a detailed set of protocols that, depending on size, depending on the kind of business they do, and so on, the different banks and the different merchants are supposed to comply with. And it includes, audit requirements, it includes training requirements, it includes technical requirements, and so on. And if this breach happens and the issuer bank then is out to the card customers, that begins a process of adjustment, contractual adjustment within this network between, you as the customer get reimbursed, but between the issuer bank, the acquirer bank, and the merchant. Now, one or all of those three, and if there's a payment processor, they may be involved in this process as well, though it gets more complicated because they contractually are not usually part of the Visa network. In any event, it begins a kind of dance among these entities to figure out who's going to be left holding the bag of the money that was reimbursed to those cardholders. And by the way, possibly also costs of investigation, cost of remediation, of figuring out exactly what happened. If it turns out, for example, that the merchant was out of compliance with PCI DSS, then the merchant may end up being on the hook to indemnify and pay back the issuer bank and or the acquirer bank, depending on how the adjustment works, of all or some of those reimbursement charges, as well as the investigation and remediation charges. All of this is happening contractually. None of it is happening because public law and public law regulation is requiring it. And you can view it and should view it in many ways as a kind of private insurance network. Now, we'll touch briefly on the concept of insurance now, and then also in a few moments when we start to talk about private law tort liability. But one of the functions of a contractual adjustment of liability is for parties to kind of know the scope of their risk, know what their possible loss might be, and then to decide whether the agreement itself gives them enough insurance against the risk of loss, and or whether they need to go out and get third-party insurance to further secure risk of loss that might not be adjusted for within the contractual network. And here you've got the major card brands are huge, well-capitalized players. The major issuing and acquiring banks are huge, well-capitalized players. Some of the merchants are, Walgreens or something like that, or Walmart. Many of the merchants are not. And so all of this is contractually adjusting that risk. Now, usually this happens really kind of opaquely to the outside world and certainly to the consumer. It's not a public regulated thing. There's not public hearings. There might be private arbitrations within the scope of the card agreements, but it's happening kind of internally. Occasionally, there are disputes that spill out publicly, and you sort of get to pull the curtain back a little bit and see some of the inner workings. And I'm just giving you here an example of a very recent case, a relatively recent case, in a trial court in Texas that went up to the Texas Intermediate Appellate Court. So here you had a merchant, Sally's Beauty Holdings, which was, a significant beauty product retailer, but not on the scale of a Walmart, that suffered a data breach, and within the internal adjudication of the PCI DSS network, Sally's ended up on the hook for something like $14 million of, ultimately reimbursement, readjusting the reimbursements to the cardholders and other costs and fees. And Sally's tried to challenge contractually the terms of PCI DSS and to challenge the basis on which they were charged. And the case is a kind of interesting discussion. Again, if you're a lawyer or a law student, it'll remind you of those confusing days of the beginnings of contract law when you're trying to figure out things like liquidated damages clauses and all of that, because it talks about a lot of those sorts of things. And at the end of the day, the court says, no, the damage adjustment provisions in the PCI DSS standards within the card brand network are acceptable, at least under California law. It was a Texas court applying California law, were acceptable as liquidated damages. Sally's Beauty agreed to them, and the other theories under which Sally's tried to get out of having to pay these amounts were rejected by the court. So it's an interesting illustration of how a contractual network potentially can work. And as Carrie mentioned, the discussion about federal comprehensive data privacy law, and we'll talk in the next session about comprehensive state privacy laws. And I think almost all industry players agree that we probably do need some comprehensive federal law, but the devil's in the details. And one of those sets of details is going to be, well, when you have a network like this, a contractual network that is really functioning under its contractual terms, is this something you need another overlay of federal regulation on, and to what degree? Or is this the kind of thing that illustrates that private contractual networks can actually handle a lot of the risks that we're talking about? Now, you might say, well, I don't know how it handles all the risks. I mean, as the credit card customer, I'm glad that I get reimbursed. But I also know that my information is still out there on the dark web, including probably my name and address as well, if someone was able to make a fraudulent charge using my card. And is the full value of my loss only the reimbursement of the charge? That's an interesting question. And there's a lot of discussion in kind of, legal scholarship and in the courts about that. Some scholars say there should be more, and that's something that a data privacy law could address. For the most part, at this point, courts have said no. Courts have said, look, your contractual agreement is what you get is, reimbursement if there's a loss. All right. So that's kind of one potential challenge to this whole idea. The other interesting thing, and if you're sort of thinking about this a little bit and mulling it around, you might say, well, wait a minute, these banks, aren't they competitors at some level? Now, the acquirer bank's doing something different than the issuer bank, though there are lots of banks that serve as both acquirers and issuers. The bigger banks will do that. How can all these parties be making agreements among each other? Isn't that an antitrust problem? And what about the smaller merchant like a Sally's Beauty, who really doesn't have any, in a sense, doesn't have any choice? I mean, that was one of their arguments in the case that I mentioned, but they've got to be able to process credit cards. There's no possibility of negotiating these liquidated damage provisions or the PCI DSS provisions. Many of them argue that smaller merchants argue that PCI DSS is too burdensome for them to comply with and too costly for them to comply with. So they end up getting hit with reimbursement charges for things that they really couldn't reasonably have done. And all of that raises antitrust concerns. And there have, in fact, been concerns raised by trade organizations that represent smaller groups of merchants over whether this sort of whole system is really an antitrust problem that squeezes smaller merchants, and in particular whether PCI DSS is A, actually effective, and B, in fact, is overly costly and burdensome to the small merchant. Those concerns have been raised at the FTC and other places, and I don't think they've ever received any traction. I don't know if they're ever likely to receive any traction. But whenever we are thinking about, to what extent can private law adjust data security and data privacy risks, we want to think on the individual side about, is it a contract an individual with a social media network, say, really can negotiate? And then on the commercial side, you want to ask, what does that network of contracts really look like? Is it really something that's sort of fair bargaining between everybody, or is it the industry, or at least the major players, kind of insulating themselves and shuffling the risk off onto somebody else? Okay. So back to the example of individual PII and how you might adjust some of those risks and what public law might overlay onto private law. And we'll be talking in the next session when we talk about state privacy laws, and kind of throughout the day and tomorrow and into our next modules as well, about some basic principles of privacy policy and law. The Fair Information Privacy principles is really the core from which a lot of the comprehensive privacy laws draw. And if you really know those basic principles, you'll have a pretty good feel for what privacy law is doing. And you'll see we're going to come back to these at the end of the day when we talk about emerging technologies like artificial intelligence. And all of these relate to that CIA triad, to confidentiality, integrity, and availability. So anonymization, right? Confidentiality. Lawful basis is there a basis for the processing? Has the individual given properly identified consent? Fairness, is the information being used with proper disclosures to the information? Does the individual know what's being done with the information? Can they have the information erased if they want it to be erased? Profiling and automated decision making, again, we'll talk about some more when we talk about AI. And how is the processing of this information being subject to some kind of oversight and control? All of these kinds of principles get built into privacy law which then puts requirements on the contracts that an entity that's processing PII is going to enter into. So you'll hear a bit about all these when we talk about the state comprehensive privacy laws, but let's take, for example, initially this idea of consent and this idea of fairness and access. So one of the very basic things every privacy regulation is going to contain as it relates to individual PII or PHI health information is going to be a privacy policy that discloses, here's what we're collecting, here's what we're doing with it, which then is going to, have some kind of binding effect because it is going to then be built into the consent, the contractual consent, as well as the legal consent, I'm going to say contractual legal consent that the individual data subject gives, right? So that in itself is going to delimit, and the law is going to delimit certain kinds of uses that can and can't be done in the consent that's given. We'll then talk about, well, what kind of consent, and you'll see that some of these laws do differentiate between consent that we would consider opt-out consent and consent that we would consider opt-in consent. And what's the difference there? Opt-out is I'm presented with a set of terms, and if I don't affirmatively say I opt out of this or that use of my data or this or that processing of my data, then you're free to process it. So the obligation is on the individual to opt out. Opt-in is to say, really the initial obligation is on the data processor or data controller to say, I processor controller am not allowed to even begin collecting and processing your PII unless you affirmatively opt in some conspicuous way to what I'm doing. You'll see that some of the state laws differ on that. If you go on and take the European module, you'll see that GDPR for most purposes is really an opt-in regime. We consider opt-in to be a more stringent regime that's more sort of consumer focused and more burdensome on business. And that's kind of the discussion we have. We have a comprehensive federal privacy law, for example. That is a key discussion that we have to have. So this is an overlay, a public law overlay onto the private law of contracts. All right, we also have the question of business to business contracts. We've been talking so far about business to consumer contracts. So what if you're a company that has data? It may be consumer PII, it may be your own trade secrets or other data, and you are hiring somebody like a cloud service provider that's going to be processing that data. Well, again, we have similar kinds of risks to you as a business. We could say, and there maybe is even a stronger case in the business to business context to say, let that all be a matter of contract. And it's fair enough to say that an individual consumer, person dealing with a social media network can't be expected to know and negotiate all these terms, and the law needs to supply some of the terms, but two presumably sophisticated businesses ought to be able to adjust for some of this together. And in general, that is the approach of US law, except we are seeing some law that is proposing in the US context an overlay of law that requires certain B2B contract terms. Now, we do have some of this in the GDPR as well. Again, if you take that module, we'll talk about that. Some of these proposed regulations go further even than the GDPR, and there's similar things in Europe as well. So the California Privacy Act, the current set of proposed regulations, I'm just going to kind of mention to you briefly so that you're aware that these exist. These are not law yet. They are proposed under the California law. In our next panel, we'll talk more about these state laws. And they're really, the most current revision is really, really current. It's just a week or so ago that these came out. These are revising a prior revision that came out a couple of months ago. But notice what all this would require. Restrictions on reuse and sale and disclosure, and it would specify what those restrictions can be. Restrictions on the mixing of one set of PII with another set of PII, unless there were some specific permission to do it. Requirements for required audit and remediation provisions, monitoring requirements on service providers, and specific contractual limitations on third parties. Now, this kind of thing is likely to be in a negotiated agreement already, and this kind of thing might as well. And both of those things are have other overlays with the obligations to the individual consumer when you're collecting their PII. These two are pretty interesting as a matter of law, because if we're talking with students or with clients, or talking to business groups, and you're talking about third-party risks in contracting, you're absolutely going to say you need to have audit provisions, you need to have remediation provisions, you need to have risk of loss provisions. Just like you're selling the bananas, you need to have all those provisions. But it's up to you to negotiate those, right? It's left to the business. If you don't, it's kind of your problem. It's your fault for not doing that. But here, as a regulatory matter, the law would require it, and to some degree or another, the contracts would be unlawful or unenforceable if they didn't have these terms. Something to really watch out for if you're interested in this space as a matter of compliance, and also something to discuss about the extent to which this is a place where it's useful for public law to be involved.